Tanveer, are you here or not? Okay, another participant is Rakhi Jha. Third participant is Arya Chandra. If you are here, then please start your presentation. If you are here, please open your mic and at least tell your name and start your presentation. Rakhi Jha, are you here or not? Arya, please turn off your mic. Arya, turn off your mic. Rakhi Jha. Rakhi, if you are here, then please start the meeting. Okay, Arya Chandra, you start your presentation. Arya, your voice is not clear. Janvi Singh,
Yes, ma'am. Hello,
you start
everyone.
your presentation.
Hello, everyone. Ma'am, my voice is audible or not?
Yes.
Okay. So, good evening, everyone. My name is Arya Chandra, and my topic of presentation is contract and its valid essentials. Okay. So, let me tell you what is a contract. So, contract is a legally binding agreement between two or more parties creating mutual obligations that are enforceable by law. Okay. It is a legally binding agreement between two parties. For example, if I say, I want to sell my house to X person. So here creates a, and that X person is interested in buying my house. So he makes all necessary preparations regarding that selling and buying process. Okay. So this creates a legally binding agreement between us. Means उन्होंने सारे जितने भी पेपर्स नेसेसरी रिक्वायरमेंट्स है सब कुछ फुलफिल किए. Now here comes the term mutual obligation. So mutual obligation means both the parties, जो भी दोनों parties हैं जो कि contract में involved हैं, have agreed to fulfill their specific responsibilities or duties to each other. Means they have mutually, concisely agreed to
1 minute,
fulfill.
Arya. 1 minute, Arya. Please, 1 minute. If you are presenting, then please at least turn on your camera.
Ma'am, actually, sorry, ma'am, but there is some issue, so that's why I have not turned on my camera.
No, you have to turn on your camera. If you are
Okay,
presenting,
okay.
if you are doing presentation, then you have to be presentable at this time, na?
Ma'am, just give me, please, ma'am, apologies. Just give me 1 minute for that. Yes, ma'am. Yeah. So, am I audible to you all, ma'am? Hello.
Yes, yes, you are.
Yes, ma'am. So, yes. So, my topic is contract and its valid essentials. So, contract, it is a legally binding agreement between two or more parties creating mutual obligations that are enforceable by law. So, as I have given the example earlier, that मैंने अपना house जो है वो sell करना है to some person X, and that man X or XYZ, whosoever it is, he is interested in buying it. So he has made all necessary requirements and preparations regarding that selling and buying of the house. Hmm. Now here comes this selling and buying process involves legally binding agreement. मतलब यहाँ पे मैंने उन्हें बेचना है, उन्हें खरीदना है, तो यहाँ पे ये जो legally binding agreement है, ये एक तरीके का हमारा contract involve करता है. लेकिन यहाँ पे एक टर्म हमारा आ रहा है. Here comes a term called mutual obligations. Means mutual obligation means both the parties in a contract have agreed to fulfill specific responsibilities or duties to each other. मतलब both have concisely and um, attentively agreed to fulfill all the responsibilities which are required in a contract. Now, here comes the term legally binding agreement. So, what is this agreement? Before understanding the contract, we have to understand what is this term called agreement. So agreement refers to a promise or a set of promises where each party gives each other something. हम अपनी डे टू डे लाइफ में बहुत सारे अग्रीमेंट करते हैं। फॉर इसका बेसिक एग्जांपल यही हो गया कि आपने किसी से कहा कि कहीं बाहर चलते हैं, उन्होंने हाँ कर दी, यहाँ पे कोई लीगली बाइंडिंग एनफोर्समेंट कुछ भी नहीं है। दिस इज मेयरली एन एग्रीमेंट कि वी आर गोइंग आउट एंड दैट्स इट। सो यहाँ से हम ये कह सकते हैं कि जो भी अग्रीमेंट्स हैं लेटर ऑन दे बिकम कॉन्ट्रैक्ट। Before, sorry, I misspelled it. All the contracts, they at their initial level are agreement, but it is not necessary that all agreements later on become a contract. So for a contract to become legally valid in its stage, there are some essential ingredients that are required to be present in a contract to become valid. It includes offer and acceptance. Obviously, I will offer something and that party will accept. This will create a legally binding agreement between two parties. Next one is intention to create legal obligation. It means that party must be interested to enforce that contract. मैंने घर बेच रही हूँ अपना, सामने वाला उस चीज को खरीद रहा है, इट मीन्स कि देयर इज एन इंटेंशन जो कि कंस्टिट्यूट करिए लेटर ऑन हमारा कॉन्ट्रैक्ट। थर्ड वन इज लॉफुल कंसिडरेशन। कंसिडरेशन इज वन ऑफ द मोस्ट important essential ingredient of a contract. Consideration means something in returns. In return मतलब मैं उन्हें ऑफर दे रही हूँ, इन रिटर्न वो मुझे अपनी एक्सेप्टेंस दे रहे हैं। दिस इज कैपेसिटी ऑफ पार्टीज। obviously both the parties must be competent to contract. ये हमारा सेक्शन 11 बात करता है कि पार्टीज कौन कौन पार्टीज हमारी कॉन्ट्रैक्ट करने के लिए दे आर एलिजिबल। ऑल द पार्टी, ऑल पर्सन हु हैव अटेन्ड द एज ऑफ मेजॉरिटी एंड आर नॉट डिस्क्वालिफाइड बाय द लॉ are considered to be eligible for entering in any contract. Pre-consent. Pre-consent is also very essential part. Without free consent, there is no contract. Lawful object and certainty of terms means there must be the certainty of terms as to what term on what terms the contract is being made. So this is something very important which one must keep in mind while enforcing any contract. And their definition: agreement is given under section 2E of the Indian Contract Act and contract is given under section 2H of the Indian Contract Act. Thank you. That's it.
Okay, thank you, Arya. I request all the participant is required to summarize and present their assigned topic within only 2 minutes. Don't take extra time, please, guys.
So apologies, ma'am,
Okay,
for that.
okay. So our another participant is Janvi Singh.
Good evening, ma'am. Good evening, ma'am. Am I audible?
Yes, you are.
My topic is dowry death under BNS. So, dowry death happens when a woman died due to burn, bodily injury, or in unnatural circumstances. The section cover dowry death is section 80 and section 80 clause 2. The punishment for dowry death is minimum 7 years and it can be maximized up to life imprisonment. The burden of proof lies to husband and his relative. Uh, there are some essentials of dowry that the death must be caused within the 7 years of the marriage and the circumstances must be unnatural. So, and the dowry under Dowry Prohibition Act, dowry is any property or any valuable thing which can be asked and which is given by a woman's family to her husband's family. And if a woman face cruelty, any kind of cruelty, it must be it can be emotional, it can be mental harassment, or it can be physical. So if the women died in and in that circumstance, and it proved that that her death caused because of dowry demand, then it then it came into dowry death. And there are cases like Nisha Sharma 2003, which is a fake case. Like when the judgment came, the it came that she filed a fake case on her husband. So yeah, there is very misuse all these sections also. But yeah, thank you. I think my time is complete. Yeah, and I want to add something like that dowry death is a cognizable offense. Police can arrest without a warrant, and the bail is not granted. When means the in cognizable cases, bail is not granted. So, yes.
Okay, so our another participant is Lalit.
Good evening, ma'am.
Good evening.
One second, ma'am. Good evening, ma'am. This is a task one of Lawlicious Internship, and my topic is Dowry Debt, presented by Detwangi from City Academy Law College. I am audible?
Yes, you
Yes,
are
you are
audible.
audible.
Thank you. Introduction. After independence, the problem of dowry debt became very rampant in Indian society, especially in 1980s. Therefore, by the Criminal Amendment Act 1986, two sections were inserted in criminal law. Section 304B was inserted in IPC, and Section 113B was inserted in Indian Evidence Act. The Section 304B was now became Section 80 of BNS, which deal with dowry debt, whereas Section 113B of Indian Evidence Act has now become Section 118 of the BSA, which deal with the presumption of dowry debt. Section 80 of BNS states that by analyzing the Section 80, we have found that the dowry debt is an offense related to marriage, where due to cruelty of husband or his relative, the woman died unnaturally within 7 years of her marriage. Whereas Section 118 of BSS state that when a question arises whether a person has committed dowry death or not, and the prosecution had proved that the soon before her death she was subjected to the cruelty or harassment by her husband or his relative, then the court will presume that the dowry death has been committed. The element of dowry death. There are majorly six elements of dowry death. Death of a woman. The death must be caused by unnatural means like burn, bodily injury, or other than natural circumstances. The death must be committed within 7 years of marriage. Then, soon before her death, she must be subjected to cruelty or harassment by her husband or his relatives. In the connection to demand of dowry, and the meaning of soon before that. The expression sooner before that has not been defined anywhere, whether in BNS or any other act. Therefore, the Supreme Court, by many on several cases, has provided their views regarding this point. In the Hiradal versus State of Delhi, the Honorable Supreme Court held that the soon before death is a figurative term which cannot be confined to a fixed specific period. Therefore, they gave a concept of proximity. In this says that there must be proximity between the death cause and when demand to the dowry. In the case of Rajlal Singh versus State of Jharkhand, the Supreme Court held that soon before her death is an elastic term. It refers to a period either immediately before death or few days or few weeks before death. In Rajveer Raju versus State of Haryana, the Supreme Court held that along with the charge of dowry death, the judges or the police officer must also put the charge of murder, Section 103 of the BNS. The presumption of dowry death, Section 118 deal with the presumption of dowry death. Here is a very specific case on that. In the Sadbir Singh versus State of Haryana, in this case, the court held that when the prosecution is able to prove the element of dowry death, Section 304B of IPC, the burden of proof shifts to accused. The punishment of dowry death, Section 80, Clause 2, deal with the punishment of dowry death, which state that the offender must be punished with the imprisonment, which cannot be less than 7 years and which may extend to the life imprisonment. Thank you for all. This is my presentation.
Okay, another participant is Subhanshi. Subhanshi. Okay, another participant is Tanmay Saha.
Ma'am, I am audible.
Yes, yes, you are.
Okay, ma'am. May I start?
Yes.
So, hello everyone. My name is Tanmay Saha. I'm pursuing BLLB honors from Bengal Law College, which is affiliated to the University of Burdwan. I'm discuss the topic about the rule of law. I'm starting with introduction. So, one of the basic principle of the English Constitution is the doctrine of rule of law. The doctrine of rule of law is accepted in the US and the Indian Constitution. The entire basis of the administrative law, jurisprudence, or legal method is the doctrine of rule of law. A.B. Dicey developed this theory in his classical work, The Law and the Constitution, which was published in the year of 1885. The rule of law ensures that no one is above the law and that the law is applied equality to all, or everyone is equal in the eye of law. It protects the right of the citizen and promote fairness and justice in the society. So the meaning, according to the Article 14 of the Indian Constitution, the rule of law means that all laws apply to all citizens of the country and no one is above the law. It also means that all human beings have to right to be treated equal before the law. So next definition, Professor William Wade defined the rule of law as the rule of law requires that the government should be subject to the law rather than the law subject to the government. So there are three main principles of the rule of law. So according to A.V. Dicey, the rule of law is one of the fundamental principles of the English legal system. There are the three meanings of the rule of law. First is absolute supremacy of law, equality before law, and the predominance of legal spirit. Now I'm discussing the absolute supremacy of law. According to Dicey, the rule of law means that no one is above the law, including the government and its official. Law is the king of kings, according to Bezos. The principle implies that all individuals and organizations are subject to the law and must abide by it. Everyone is bound to follow the law. So equality before the law. So Article 14 of the Indian Constitution define the state shall not deny any person equality before law and equal protection of law. So this principle emphasizes that the law should be applied equally to all individuals. It ensures that no one is discriminated against based on race, gender, social status, or any other characteristics. Third one is predominance of legal spirit. Dicey highlighted the importance of legal system based on established principle and precedent rather than arbitrary decisions. This means that the legal system should be characterized by the principles such as fairness, justice, and due process. So one landmark case of the rule of law under Indian Constitution is the case of Nanda Bharati versus State of Kerala, 1973. So right to equality grounded under Article 14 of the Indian Constitution. The Supreme Court held that the rule of law is a part of the basic structure of the Constitution and therefore it cannot be destroyed even by the Parliament by using the Article 368. The conclusion, the diocese theory rule of law is still influential and played a significant role in English Constitution. So thank you.
Okay. Another participant is Kashish Agrawal. Kashish Agrawal.
Hello. Hello, ma'am. Am I audible?
Yes.
Well, hello everyone. Myself Kashish Agrawal, and I am a second year student of BLLB from Rajasthan University 5-year Law College. And my topic for presentation is murder. So it's a section 101 of BNS, and there are two essentials of murder, which are essentials of crime as well. That is actus reus and mens rea. Actus reus refers to guilty action, and mens rea refers to the guilty mind. So the term mentioned is culpable homicide, which refers to killing of a person, and the culpable homicide amounts to murder when act is done with either act is done with intention of causing death, or secondly when the such injury is caused which is capable of causing death in ordinary course of nature. Third is causing such body injury as offender knows to be likely to cause death of a person. And the last one, act which is imminently dangerous that it must in all probability cause death or bodily injury as is likely to cause death by person committing the act. So there are exceptions to the crime of murder as well. That is sudden and grave provocation. Secondly, in exercise of good faith or private defense. Thirdly, in advancement of public justice. Any if any public servant exceeds the power given to him by the law. And fourthly, in a sudden fight or heat of passion. And the lastly, person who is consent has been given, who is the age of above 18 years. So that was all from my side. I hope you understood well.
Okay, another participant is Kashish Nan. Kashish, you are not audible.
Am I audible, ma'am, now?
Yes, yes.
Hello, everyone. Today I will present on law of tort and I will give you guys an overview about it. So, what is tort? A tort is a civil wrong, which means a wrongful act that a person does to another person which cause harm, and the law provides remedy for it. So, next, how do we know that a wrongful act is a tort? So there are three essentials for a wrongful act to be considered a tort. First, a wrongful act or omission, which means something needs to be done or not done. Second, a legal damage or injury, something that acts that act must cause a harm to another person. Third, a legal remedy must be present. So next, I will tell about the general defenses in tort. So the general defenses uh, can be a act of God, which means natural disaster. Second, consent, uh, consent, which means a person give consent to take a risk. A common example can be a person go to a stadium and a ball hit, then he cannot be sue a batsman or any owner of the stadium. Next is the inevitable accident. This accident cannot be prevented with even with the reasonable care. Next is self-defense. Let me tell you about the some common torts. So first is negligence. Negligence is a failure to take care of a reasonable take. Sorry. Uh, Negligence is a failure to take care of something which cause harm. Next is defamation. Defamation is a harm to someone's reputation by their by a false statement. Next is nuisance. Nuisance is a interfere to someone's goods or property. Next is trespass. Trespass is an unauthorized entry to someone's land. Next, there are some remedies in torts which is given to a victim who has suffered loss. These remedies can be damages, which is the financial compensation to the person. Second is injunction. Injunction are the which court order to stop a wrongful act. Third are the restitution. Restitution means return of something unlawfully or illegally property. So, in conclusion, tort is all around us, whether it is a noisy neighbor or a careless driver. So, law of tort helps people to protect their right and ensure that the person who caused harm take fully responsibility of it. Thank you.
Another participant is Lavish Kumar.
Hello everyone. Hello, good evening everyone. Am I audible?
Yes, yes.
So, myself Lavish Kumar Bobaria, and my topic is attempt to murder. As the it phrase suggests, an action performed with the intention and knowledge of killing someone, and if due to that act that is caused, it would constitute murder. सो लिटरली इट मीन्स कि मतलब किसी भी इंसान के द्वारा दूसरे इंसान की दैट मर्डर करने के इंटेंशन से या मर्डर करने के नॉलेज से किया गया कोई भी काम अटेम्प्ट टू मर्डर कहलाता है और यदि उस एक्ट से सामने वाले की डेथ हो जाती है तो वो मर्डर कहलाया जाएगा सो अटेम्प्ट टू मर्डर और जो व्यक्ति अटेम्प्ट टू मर्डर करता है उसे 10 साल तक की सजा होती है और उसके साथ में उससे फाइन भी पे करना होता है और यहाँ तक कि अगर उसके द्वारा किए गए एक्ट से सामने वाले व्यक्ति को या पर्सन को कोई इंजरी हो जाती है तो ऐसे केस में उसे लाइफ इम्प्रिजनमेंट भी हो सकती है या फिर जो 10 साल की सजा पहले बताई गई है वो भी दे हो सकती है अटेम्प्ट टू मर्डर सेक्शन 109 के अंदर डिफाइंड है बीएनएस के अंदर 2023 में और ये एक कॉग्निजेबल ऑफेंस है एज वेल एज नॉन बेलेबल ऑफेंस है मींस जो एक्यूज्ड है उसे बिना किसी वारंट के अरेस्ट किया जा सकता है एंड नॉन बेलेबल है बिकॉज इसमें एक्यूज्ड बेल सीक कर सकता है लेकिन वो कोई गारंटेड राइट नहीं है बिकॉज कोर्ट के पास ये डिस्क्रिप्शन है कि उसे बेल देनी है या नहीं देनी है सो फॉर एग्जाम्पल जैसे ए जेड को मारने के इंटेंशन से कोई गन खरीदता है उसे लोड करता है तो जब तक वो गन उसने यूज नहीं किया तब तक उसने ए ने कोई ऑफेंस कमिट नहीं किया लेकिन जैसे ही ए जेड के ऊपर गोली चलाता है तो यहाँ पे ए ने एक ऑफेंस कमिट किया है जो कि सेक्शन 109 के अंतर्गत डिफाइंड है और इस केस में यदि जेड उस गोली से घायल हो जाता है तो ऐसे केस के अंदर ए को जो सब सेक्शन 1 है उसके लेटर पार्ट के अकॉर्डिंग ए को पनिश किया जाएगा विच मीन्स उसे लाइफ इम्प्रिजनमेंट दी जा सकती है या फिर 10 साल की सजा दी जा सकती है सो थैंक यू
Another participant is Rajiv Kumar.
Good evening, everyone. My name is Rajiv. Hopefully I'm audible and visible to all of you. Uh, समय की पाबंदी है इस वजह से मैं बहुत समय आपका नहीं लूँगा जो टॉपिक मैंने चूज़ किया हुआ था प्रेजेंटेशन के लिए और वीडियो भी मैंने सेम इस पे बनाया हुआ है ये क्या कहते हैं रॉन्गफुल एक्ट और इसके एजेंशियल्स पे है तो रॉन्गफुल एक्ट कोई भी ऐसा एक्ट या ओमिशन है जो कि रॉन्ग है अगर लेमन लैंग्वेज में हम लोग कहें या फिर रॉन्गफुल एक्ट अगर थोड़ा कंसेप्चुअल में कहूँ तो रॉन्गफुल एक्ट का मतलब है कोई भी ऐसा एक्ट या ओमिशन जिसकी वजह से किसी के लीगल राइट का इन्फ्रिंजमेंट हो रहा हो तो इसके एजेंशियल्स की अगर मैं बात करूँ तो इसके एजेंशियल्स हो सकते हैं जैसे कि कोई एक्ट या ओमिशन एक्ट और ओमिशन होना चाहिए और वो एक्ट और ओमिशन जो है किसी के लीगल राइट को वायलेट करना चाहिए उसकी वजह से किसी को हार्म या डैमेज होना चाहिए इसके अलावा इसका जो कॉजेशन है मतलब जो आपको हार्म या डैमेज पहुंचा है ये उसी एक्ट या फिर ओमिशन की वजह से ही होना चाहिए इस पे बहुत सारे केस लॉस भी हम लोग जोड़ सकते हैं या कैटेगरी वाइज को डिवीजन भी दे सकते हैं लेकिन अगर आप कैटेगराइज करना चाहें रॉन्गफुल एक्ट को तो वो उस एक्ट के नेचर पे के बेसिस पे करेंगे इसके अलावा अगर मैं केस लॉ की बात करूँ तो जैसे एसबी वर्सेस वाइट का केस था जिसमें वो वोट देने जाते हैं एसबी जो प्लेंटिफ हैं लेकिन क्या कहते हैं उनको रोक दिया जाता है वैसे ही भीम सिंह वर्सेस स्टेट ऑफ जम्मू एंड कश्मीर था जिसमें वो एमएलए होते हैं भीम सिंह और वो जाते रहते हैं असेंबली सेशन अटेंड करने के लिए पर उनको रोक दिया जाता है तो टॉर्ट में लाइबिलिटी प्रूव करने के लिए प्लेंटिफ हैज टू प्रूव दैट द डिफेंडेंट हैज कमिटेड एन रॉन्गफुल एक्ट दैट्स ऑल थैंक यू एवरीवन
Next participant is Samina Parveen.
Good evening, ma'am. My name is Samina Parvin. I am from Brunel University. My topic is Article 32. We all know the Latin phrase that ubi just ibi remedium, which means where there is a right, there is a remedy. Dr. B.R. Ambedkar considered Article 32 as the heart and soul of the Constitution. Article 32, Clause 1 empowers the people to move to the Supreme Court for the enforcement of fundamental rights. Traditionally, we have the concept of locus standi, which means only the person whose rights are being violated has the right to move to the court. But nowadays, the ambit of Article 32 has been increased by introducing the concept of PIL, which allows the individuals to move to the court for the enforcement of fundamental rights, even they are not directly violated. Article 32, Clause 2 talks about five types of writs, which are habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Article 32, Clause 3 talks about that the Parliament has the power to authorize any other court to issue the writ for the enforcement of fundamental rights, but within their local jurisdiction. Article 32, Clause 4 talks about that the right under Article 32 cannot be suspended except as provided by the Constitution. But we all know that Article 359 states that the Article 32 shall be suspended by the order of the president, not automatically. That's it. Thank you, ma'am.
Next participant is Shadma. Another participant is Arya Mandas Sharma.
Hello, am I audible?
Yes.
Yeah, just a second. Um, Good morning, all. Good evening, all. This is Arman Dasharma. I'm from Gitaratan International Business School, affiliated to GGS IPU. I will be just going to the brief of the whole topic, contract law, as my fellow participant already explained it. So let's start with it. Contract, and nowadays everything you indulge in has a contract in it. Either it be food, either it be your website, either it be any article that you're reading, either it be even a video on YouTube channel. Everything contains a contract. Now, what is a contract? Before we know what is a contract, the contract framework in India is governed by Indian Contract Act 1972. And now let's begin to understand what is a contract. Now, Indian Contract Act 1972 defines it as a contract is an agreement enforceable by law. A contract is an agreement which is enforceable by law. Um, Formed between two or more parties. It results in obligation that are legally binding. Now, there are terms that we need to understand. A contract is an agreement. 2E of Indian Contract Act states that when parties promises each other and forms a mutual agreement to achieve something, that as a but an agreement is enforceable by law. This thing enforceable by law. So it's not a contract. A contract is agreement as well as enforceable by law. So unless and until it is not backed up by law, you cannot call it a contract. Thus, the legal liability, the legal obligation is that the parties should agree voluntarily that uh, the contract would have a legal validity, and also uh, we come to the legal agreement. It must contain legal terms and conditions that are permissible under law, ensuring that it's not void or voidable. Now, what are the essentials of a contract? Offer, acceptance, consent. Now, a contract, how it is formed? An offer is either given by the lawyer, given by the offerer himself, and also given by the acceptor. And it cannot be weak. If you say, I'm going to sell a ball, you have to know what type of ball. It cannot be that I'm taking a plastic ball, you made it metal. Consent. Elements of offer must be communicated to the offer. Again,
Aryaman, your voice is
by
not clear.
Hello, am I audible now?
No, it's glitching.
Hello, ma'am, am I audible?
Yes, now you're audible.
Yeah, sorry about that. So where was I? I was. Did you miss the whole part, or can I continue from here?
No, you continue.
Okay. So again, back to the topic: offer, acceptance, capacity to contract, and consideration. And acceptance must be there, as we said. Acceptance must be there, and acceptance should be communicated. The communication should be sent, and should be the communication sent at the relevant time. Next is the contract. There is a capacity of contract. A person, not everyone can contract. A person of some who is not disqualified by law, and a person who is a major according to Indian Majority Act above the age 18 can only form a contract. And one of the most important thing, consideration. A contract is a, you can think it as a formula of agreement plus legal balance. So without consideration, you can form a contract. This was contract that thing. It does not it does not under the same term as for and essentials. Um, uh, Acceptance must be clear, offer must be clear, both should be communicated, both general or implied. Implied in the sense, if I'm going to, if I'm, it's implied that when I step in the bus, I have to pay for the fare. Acceptance in general, like the greatest example is Carlton versus Alcoholic Smoker Company, in which there's an advertisement of a different policy if their product didn't work, and later on this the company said, hey, this was just an advertisement and we didn't offer them, but they said, listen, there is nothing like that. If you have given an ad, it could be that means the acceptance could be implied. Once you set the ad, once it's a general it forms a general contract. Once it's published, it's a contract. This comes under general contract. That means general and implied. Now, invitation to offer is different from offer. It's an essential tool. It's a part of a contract. But invitation or offer doesn't hold any legal value. It's just saying that hey, I can make offer if you want, like display, like shopping map on a display set on a window, or some kind of items with price tags on it. It's an offer to invitation to offer. It's different from offer. Now conclusion. Contract is essential for daily life. It is not just it's a new term. It evolved from ancient time, like modern to ancient civilization to modern civilization, and it will keep on going and governs how the world actually works. It is important that there is clarity in communication while forming a contract. And again, as I said, the contract system in India is governed by Indian Contract Act 1972. Thank you, and sorry for the delay again. Thank you all. This is all.
Next participant is Purna Sahu. Purna Sahu. Next one is Shagun Joshi. Abhinav Sharma. Abhinav Sharma. Another participant is Ankit Vardhani.
Yes. Am I audible?
Yes.
So my name is Ankit Vardhani. My today's topic is I'll be discussing about strict and absolute liability, which comes under tort law. I am a student of third year LLB from Janara and Vyas University. So what is strict liability? So strict liability means a liability without a fault. It was first introduced in the case of Rylands versus Fletcher. It was the case held in 1868. And according to this rule, if a person brings any dangerous thing onto their land and it escapes causing harm, they will be held liable, even if they are not, even if they were not negligent. But there are certain exceptions to it. And what are these exceptions? The exceptions are like an act of God, like an earthquake or flood, and the plaintiff's own fault. And the act was done with plaintiff's consent. The use of land was natural. These defenses can reduce or eliminate liability under this doctrine. So these were the exceptions. But in Indian context, there is another concept which is called absolute liability. In India, Supreme Court went one step ahead in MC Mehta versus Union of India case. It was the case held after oilum gas leak in 1987. The court has developed the rule of absolute liability. It means that if any industry or enterprise engages in hazardous activity and harm is caused, then it is fully liable with no exceptions. Aren't any exceptions in this principle, absolute liability. And this rule is very unique to India. And it was designed to protect public safety. Then if we compare strict and absolute liability, then there are some key differences. For example, strict liability allows some exceptions, while absolute liability doesn't have any exceptions. And if we talk about the origin, then strict liability was originated in England, but absolute liability is an Indian innovation. And if I talk about its relevance today, then these principles are still highly relevant because we have seen that like incidents like Bhopal gas tragedy, Vizag gas leak, and others. So absolute liability ensures that companies are held accountable for endangering lives and environment. It promotes safer industrial practices and better risk management. And if I would conclude the topic, then I would say that strict and absolute liability are crucial tools in tort law because they ensure justice and accountability. They show that how the law evolves to address modern problems and protects people's rights. Thank you.
Next participant is Simran.
I'm audible.
Yes,
Is I'm audible?
yes, you are audible.
Okay. Hello, everybody. I'm Simran, student of third year, currently pursuing BLLB from City Law College, Jankipuram. So, my topic of presentation is theft. Theft is defined under Section 303 of BNS. Theft basically means when somebody physically removes the property of another without the consent of his owner and with the intention of depriving it permanently. Now, the essentials of theft. First essential is dishonest intention. Dishonestly word is basically defined under 2 clause 7 of BNS, which means dishonestly means causing wrongful gain to one person and on another hand causing loss to another person. Now, second essential is it must be movable property. The subject matter of theft is movable property. As long as the thing is attached to the earth, not being movable property, it is not the subject of theft. But it will become capable of being the subject of theft as soon as it is severed from the earth. Now, the third essential is taking out of possession of another person. Theft is basically of an offense against possession and not ownership. And doesn't matter for the purpose of theft whether the person from whose possession the property is taken is a true owner or not. In reference to this case, Pyarelal Bhargav versus State of Rajasthan, in this Supreme Court observed that it is not necessary that property should be in possession of the true owner only. And the fourth essential is taking without the consent of another person. In order to commit theft, property must be moved without the consent. And last essential is moving the property. For the offense to be complete, there must be a dishonest moving of the property. The least removal of the thing taken from the place where it was before amounts to taking through may not be carried out. In reference to this, a case K.N. Mehra versus State of Rajasthan. In this, Supreme Court held that even a temporary retention or deprivation is enough to show that offense has been committed. Now, the punishment for the first conviction, the offender shall be punished with imprisonment for a term which may extend to 3 years plus fine or both. And for
In case of second or subsequent conviction, the person shall be punished with rigorous imprisonment for a term which shall not be less than 1 year, which may extend to 5 years, and with fine. Thank you.
Next participant is Divyansh Mishra.
Good evening, everyone. My name is Divyansh Mishra. My topic is bailment and pledge. So, bailment is provides in section 148. A bailment is the delivery of goods by one person to another for some purpose upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the direction of the person delivering them. And if I'm talking about essentials of bailment, there should be two parties, bailer and bailee. Bailer who is deliver the good and bailee who receives the good. The delivery of goods may be actual or symbolic. Delivery upon some purpose may be purpose reward or gratuitous. Delivery upon some contract, a return or disposal according to the bailer. And duty of bailer, there is only one duty of bailer which is provided in section 150. Bailer's duty to disclose fault in goods bailed. And if I'm talking about the duties of bailee, so duty of reasonable care of goods, duty not to make unauthorized use of goods, duty not to mix, duty to return, duty not to set up justiciary, duty to return increase. राइट्स ऑफ बेली की अगर बात की जाए तो राइट टू लीन, राइट टू एक्सपेंसेस, राइट टू कंपनसेशन एंड राइट टू sue. And if I'm talk about pledge, so here comes be section 172. The bailment of goods as security for payment of a debt or performance of a promise is called pledge. The bailer in this case called the pawner and the bailee is called the pawnee. And essentials of the pledge are delivery of goods by adornment and delivery as secure as surety of payment or performance of promise. It is also contractual and goods of return and restoration. Rights of pawner and pawnee. So rights of pawnee are rights of retainer, right to extraordinary expenses, right to sell, and rights of pawner, right to redeem only. And if we talk about who can pledge, so pledge by mercantile agent only and pledge by person in possession under voidable contracts. And the differences between bailment and pledge, bailment can have various purpose while pledge is especially for securing a debt. In bailment, the bailee generally cannot sell the goods, while in pledge, the pledgee has the right to sell the goods upon default. Thank you.
Next participant is Saloni Jain.
Hello everyone, myself Saloni Jain. I'm currently in third year LLB. So my topic is defamation, and defamation is basically a legal concept that protects a person's reputation from false and harmful statement made by others. Now let us talk about what defamation basically is. Defamation is an act of making a false statement about someone that harms their reputation. It can be of two forms, libel and slander. Libel means the written defamation that is being, for example, like being published something in newspaper or social media, etc. And slander is spoken defamation. Spoken defamations, like you can speak, defame someone by using your words in your speeches and by spreading rumors about that person. Let's talk about the essential elements of defamation. So first, the statement must be false. Secondly, it must be published or communicated to others. Third, it must cause harm to the reputation of that person. And fourth, there must be an intent or negligence on the on of the, from the part of that person. Now, in Indian perspective, defamation is both civil wrong and criminal defamation. So, if the defamation is civil defamation, it can lead to monetary compensation, while agar criminal defamation hai, to it can lead to imprisonment or fine or even both. There was a very famous case law of Subramanian Swamy versus Union of India, in which the Supreme Court upheld the constitutional validity of criminal defamation, stating that reputation is an integral part of the right to life under Article 21 of the Constitution. But there are some defenses that are being available for that person जिसने defame किया है, but वो actually defamation नहीं होगा. That is truth. If the person says truth about that person, जिसका लग रहा है कि उसकी reputation harm हुई है, but the statement or the published sentences that are being made about that person is true. Second, fair comment. But it means if a person is giving its honest opinion on a matter of public interest. And third, privilege. There are certain communications that are being privileged, like something said during the parliamentary debates or during court proceedings, etc. now, as in today's growing society, social media upholds a very important part, an integral part of our day-to-day life, and there comes the defamation of cyber defamation, which means false and defamatory content posted or shared online. It targets a person, a group, or an organization. It requires publication to at least one third party, and it causes harms to the victim's reputation. Now, to conclude my presentation, I would say defamation laws aim to balance two important rights, that is, the right of free speech and the right to protect one's reputation. With the rise of social media, it is more important than ever to think before we speak or we post. Thank you.
Next participant is Srishti Singh. Srishti Singh.
Good evening, all of you. My name is Srishti Singh. I am a student of fifth semester from City Academy Law College. My topic is kinds of contract. There are three subdivisions on the basis of creation of formalities. Just a second. On the basis of creation of formalities, express contract. The contract which is not made by which is made by words, oral or written, that is called express contract. Implied contract, the contract which is not made by only words, that is called implied contract. Quasi contract, the contract where legal obligation arises not without offer and acceptance, that is called quasi contract. On the basis of execution or performance, executed contract. एग्जीक्यूटिव कॉन्ट्रैक्ट वो है जहाँ की ऑफरी और ऑफर में से दोनों ने अपने 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 राइट्स को फुलफिल कर दिया है, और एग्जीक्यूटिव कॉन्ट्रैक्ट में जिसमें कि ना ऑफरी ने और ना ही ऑफरर ने किसी ने भी अपने राइट्स को फुलफिल ऑब्लिगेशन को फुलफिल नहीं किया हो. On the basis of enforceability or validity, on the basis of there are 5 subdivisions. Valid contract, contract which fulfills the essentials of section 10 of the Indian Contract Act 1872, that is 1972, that is valid contract. A contract which is enforceable by law is valid contract. Void contract, void contract is defined in section 2J of Indian Contract Act. The contract जो कि starting से void नहीं होता बल्कि subsequent event पे void null and void declare हो जाता है, उसे void contract कहते हैं. Void agreement, void agreement is defined under section 2G. The agreement which is not enforceable by law is void agreement. Voidable contract, voidable contract वो होता है जो voidable contract section 2J में defined है. Which ceases to be enforceable by law becomes void when it ceases to be enforceable. Illegal or unlawful contract, contract which is defined under section 23. Agreement is illegal or unlawful if its object or consideration is forbidden by law, immoral, and again the public policy, and if it is harm the public property or public peace. That's all. Thank you.
Next participant is Ridhima Tripathi. Next participant is Sanskar Verma.
Hello.
Good evening, ma'am. Good evening. Am I audible?
Ma'am, myself Vidya Tripathi. Sorry for delay.
Okay. Sanskar, please wait for 5 minutes. Ridhima, you start.
Okay, ma'am.
Good evening, everyone. Myself, Riddhima Tripathi, and currently I'm pursuing BA and LB honors from City Academy Law College. Today, I'll be speaking on one of the most fundamental pillars of the law of contract, that is concept of consideration. So basically, consideration is something in return. That is, it is the price one party pays for the promise of the other. Section 2D of Indian Contract Act or abstinence or promise is called consideration for the promise. So now for consideration to be legally valid, there are certain elements that are it must move at the desire of the promiser. A second is it can move from the promisee or any other person. Third is it may be past, present, or future. And fourth one is it must be real or unlawful. Sorry. Here a case law is given here. That is Curie versus Misa. The court described consideration in this case as some right, interest, or benefit accruing to one party, or some forbearance, loss, or responsibility taken by other. Now, there is a general rule that is given under Section 25 of Indian Contract Act, that is no consideration, no contract, which means when an agreement is made out of love and affection between near relatives, when a promise is made to compensate someone who has already voluntarily done something, when a person agrees up to pay time pair debt, and of course gifts that have already been completed, they require no consideration at all. Before I conclude, let's clear a confusion. Consideration is not the same as motive. Consideration is what you give for it. In conclusion, consideration is the spine of enforceable promises. It ensures fairness, balance, and accountability in the contractual world. Without it, promises would be no more than casual words. Honorable, perhaps. In the courtroom of law, it's not love or loyalty that makes a promise binding. It's consideration, the lawful currency of contracts. That's all. Thank you so much.
Next participant is Sanskar Verma.
Good evening, ma'am. Ma'am, I am audible.
Yes, yes, you are audible.
So, myself, Sanskar Verma, and I am a fourth year law student at Sardar University. And today, my topic is I am going to explain the leading case of Lalman Shukla and Gauri Dutt. So, what happened in this case was there was a servant who was known as the Lalman Shukla, and he was a servant under the Gauri Dutt. So one day the nephew of the Gauri Dutt went missing, and so he asked his servant that to bring back his nephew. And his nephew, after a 1 minute, ma'am, and जो उसका मैम नेफ्यू होता है वो हो जाता है और वो उसके भेजा जाता है लालमन शुक्ला जाता है उसके नेटवर्क ढूंढने के लिए। तो उस टाइम पे ही जो गौरी थे वो एक ऑफर निकालते हैं। ऑफर में ये बोलते हैं कि जो भी मेरे नेफ्यू को ढूंढ के लाएगा मैं उसको 500 एक का डिवॉर्ड दूंगा। तो इस टाइम पे जो गौरी दत्त होते हैं वो हरिद्वार में होते हैं, उनको उस ऑफर के बारे में पता नहीं होता है। तो बहुत टाइम के बाद जो होते हैं लालमन शुक्ला वो उनके नेफ्यू को लेके वापस यहाँ पे आ जाते हैं। बट उस टाइम पे वो ये बोलते हैं कि मुझे रिवॉर्ड चाहिए। बट जो लालमन गौरी दत्त होते हैं वो ये बोलते हैं कि जब मैंने ऑफर मेड किया था तो तुम यहाँ पे थे नहीं। तो इस बात पे जो गौरी दत्त लालमन शुक्ला होते हैं वो केस फाइल कर देते हैं इलाहाबाद इलाहाबाद हाई कोर्ट में। तो इशू कोर्ट के सामने ये होता है कि क्या जो एक्सेप्टेंस किया था लालमन शुक्ला ने जो उनके नेफ्यू को लेके आया था घर पे, क्या वो वैलिड एक्सेप्टेंस था? और जो क्या ये कॉन्ट्रैक्ट यहाँ पे लालमन शुक्ला और गौरी दत्त के बीच में एग्जिस्ट करता है नहीं करता है? तो सिंपली इस केस में कोर्ट ने ये हेल्प किया था कि जो ऑफर की जो नॉलेज थी वो ऑफरी को नहीं होती है। तो यहाँ पे मैंडेटरी होती है कि अगर कोई कॉन्ट्रैक्ट चाहिए तो वहाँ पे वैलिड एक्सेप्टेंस होनी चाहिए। और यहाँ पे वैलिड एक्सेप्टेंस नहीं थी क्योंकि जो नॉलेज थी ऑफर की वो ऑफरी को नहीं थी, जो कि लालमन शुक्ला थे। तो कोर्ट ने इस केस में सिंपली ये हेल्ड किया कि जो लालमन शुक्ला है वो रिवॉर्ड के लिए एंटाइटल नहीं है। थैंक यू।
Next participant is Gargi.
Good evening, ma'am. Am I audible?
Yes.
Okay, just give me a second. Is my presentation visible on the screen?
Yes, it is.
Okay. Good evening, everyone. My name is Gargi Talukdar, and today I'll be briefly walking you through the essentials of a valid contract under the Indian Contract Act 1872 as per Section 10. As I'm aware that we have a time strain of 2 minutes, so I would be keeping the summary as crisp as possible. Now, to understand the essentials of a contract, we need to understand what exactly a contract is. Now, a contract is an agreement which is enforceable by law. However, it is needed to be understand that not every agreement is legally valid. There are certain essentials which must be present. Now, these are the 8 essentials that is covered or underlined under Section 10 of the Indian Contract Act. The first essential we have is offer and acceptance. Now, it is very important while forming a contract that there must be a clear offer by one party and absolute acceptance by the other. I would like to emphasize on the word absolute because if the acceptance is not definite or clear, same goes with the offer as well. It needs to be communicated. That is when the contract is considered to be a valid contract. The next we have is intention to create legal relations. Now, parties must intend to create legal obligations, and under this, it is needed to be noted that social promises they do not qualify as legal intentions. As you can see, that I have mentioned a case law regarding Belfort versus Belfort and married versus married. In one case, that is Belfort versus Belfort, the social promise was not considered to be a legal intention. However, in the case of married versus married, when there was a written agreement, it was considered to be intention to create. It was considered to be intention to create legal relations with both the parties. The next we have is the lawful consideration. Now, each party must give or promise something of value. Now, this something of value is what we call as consideration, and this something of value needs to be lawful in nature. The fourth one we have is capacity to contract. Now, it is important that the parties involved in the contract must be of major, that is, they should be of 18 years and above, they should be of sound mind and not disqualified by law. The next we have is free consent. Now, the consent must be given freely, not due to coercion, undue influence, fraud, misrepresentation, or mistake. The next essential that we have is lawful object. Now, it is very important that the purpose of the contract must be legal and not immoral or opposed to the public policy. Section 23 of the ICA deals with the lawful object as per the requirements. The next we have is not expressly declared void. Now, the contract must not fall under the void agreements like those restraining trade or marriage or even restraint of legal proceedings. Now, these agreements are already declared void under the statute. Thus, these agreements does not fall under the purview of any valid contract. The next we have is certainty and possibility of performance. Now, it is important that the terms of a contract must be clear and the agreement must be capable of being performed. Now, in the case of Taylor versus Caldwell, the music hall was burned. Thus, it was impossible for the performance to happen. Thus, the court ruled in favor of Caldwell. To summarize or to sum up, I would like to say that these elements that I have discussed during this presentation, it must be present for a contract to be valid and enforceable. If even one is missing, the contract may be void or voidable. Thank you so much.
Next participant is Santanu Mandal.
Ma'am, am I audible and visible?
Yes, you are audible.
Namaskar, I am Santanu Mandal. Today I am presenting one of the important topic of the law of the contract, that is consideration, as I choose it topic of my video. Firstly, consideration is defined under Section 2 Clause D of the Indian Contract Act 1872, which states, when at the desire of the promisee or any other person has done or abstained from doing, promises to do or to abstain from doing, does or abstain from doing something such act, abstinence from promise, called consideration for the promise. Now, in this definition, the meaning of some words are very important. Firstly, abstain. Abstain means not to do something. And secondly, desires is very essential as it's determine the one of the greater part of the consideration, that is adequacy of the consideration and the validity. For an example, if a promiser wants a specific radio, then the consideration should be that specific radio only, not any other one. So desire means the wants of the promiser or the demands of the promiser which the promisee or any other person in his behalf have to give for a valid consideration. Now, the meaning of some phrases are very important in this definition. Firstly, has done or abstain from doing. Has done and abstain from doing represent past consideration. Secondly, does or abstain from doing represent present consideration. And third and lastly, promises to do or to abstain from doing represent future consideration. Now, from this definition, if we break down the meaning of the words which the provision itself want to convey, then the meaning of the consideration will be consideration is something which the promisers gave out of his own desires, out of his own wants, and it to be given by the promisee to that contract or any other person, which may be past, present or future, or and such act may be something to do or not to do which the promiser wants. Now, if we follow the definition, then we have the essentials and the types of consideration from this definition. The first essential of a consideration is the desire of the promiser. Consideration may be anything and it may or may not be adequate, that doesn't matter, but the only requirement is it must be accepted, demanded or wanted by the promiser. The second essential of a consideration is it must be lawful. That's another part defined under the other parts of the Act of 1872. Secondly, the types of consideration. Consideration may be as stated past, present or future. In case of past consideration, firstly, past consideration means something done in past, which the promiser accept that you have done this work and I accept it that you have done for me, I am getting some benefit and I will pay you for that. This type, the recognition of this type of consideration is called the past consideration. But in case of past consideration, there are two rules. First rule is the promiser must accept the work of the promisee as consideration which he has done in past. And secondly, it must be non-voluntary in nature, that is to say non-gratuitous in nature. It means that the promisee must do the act not out of his own will but out of some expectation. There is the second is present consideration. Present consideration is something to be done or not to be done which the promiser wants. Present consideration is not complicated one, is that simple. And the thirdly, future consideration is promises to do some act as consideration. That's called the future consideration. That's the promise is not promise or any other person not giving, not doing right now, but he will done it on future date by virtue of a promise. That's the future consideration. Now there are some extra points which can be added with this. First point is if there is a son who is disturbing his father that my brothers were given more property than me, and if his father says that okay, if you stop complaining me, then I will release you from your debt. Now it can be consideration. Complaining, stop complaining to his own father. It was held in White versus Bullet case. No, it can't be, because it does not constitute the essentials of the essentials of a legal consideration and the essential of a social consideration. For this purpose, I would refer one book, that is The Province of Jurisprudence Determined, written by Austin. That's all.
Next participant is Shraddha Khemka.
Yeah. Good evening, ma'am. I'm Shraddha Khemka, a third year law student, and today I'll briefly explain what the doctrine of frustration under the Indian contract law is. So, the doctrine of frustration comes into play when something unexpected happens after a contract is formed, which makes it impossible, illegal, or completely impact practical to carry out the contract. In such a case, the law says that the contract becomes void and both parties are discharged from further obligations. So this is a codified. This is codified in Section 56 of the Indian Contract Act 1872. It states that if a lawful contract becomes impossible to perform due to events beyond the control of the parties, it becomes void. This idea is very simple. The law does not compel the impossible. And some real life examples, including a building being destroyed by fire, a government ban, or the death of a key person needed for performance. A famous Indian case on this is Satyavrata Ghosh versus Mugniram Bangar, where the Supreme Court explained that frustration does not only mean physical impossibility, even a serious change in circumstances can be counted. Another well known case from English law is the Taylor versus Caldwell, where a music hall was burned down before the event. The court held that the contract was frustrated. However, frustration does not imply if the event was self-caused or just made things harder or more expensive, rather. So it must truly defeat the purpose of the contract. In conclusion, the doctrine of frustration ensures fairness where unexpected events make performance impossible, and it allows the law to step in and release both the parties from further duties. Thank you.
Next participant is Siddhant Kumar Pandit. Next participant is Utkarsh Yadav. Next participant is Amber Kohli.
Hello everyone. Hello everyone. My topic is bailment and pledge. Bailment is delivery of goods from one person to another for some purpose. मतलब कोई भी ऐसे गुड्स कोई डिलीवरी जो एक सर्टेन काम के लिए दी गई हो एक कॉन्ट्रैक्ट के अंदर और जब वो काम पूरा हो जाए तो उस सामान को रिटर्न कर देना होता है। बेलमेंट के अंदर दो पर्सन के बीच में कॉन्ट्रैक्ट होता है। पहला होता है बेलर और दूसरा होता है बेली। बेलमेंट 148 से लेके 171 के बीच में दिया गया है। फिर आता है प्लेज। प्लेज जो है वो सेक्शन 172 से लेके 100 जो होता है वो एक स्पेशल काइंड ऑफ बेलमेंट होता है जिसमें जो डिलीवरी ऑफ गुड्स है वो डेप्थ के सिक्योरिटी के तौर पर या फिर किसी प्रॉमिस के परफॉर्मेंस के लिए दिए गई होती है। प्लेज में दो पर्सन के बीच में कॉन्ट्रैक्ट होता है पॉनर और पॉनी। अगर इस केस में पॉनी अगर जो है वो पॉनर जो है अगर वो डिफॉल्ट करता है डेप्ट के पेमेंट में तो इस केस में पॉनी जो होता है वो गुड्स को रिटेन भी कर सकता है और उनको सेल भी कर सकता है। वहीं पे बेलमेंट में गुड्स जो है वो सेल नहीं होते हैं। बेलमेंट में जो ओनरशिप ट्रांसफर है वो नहीं होता है, इसमें सिर्फ गुड्स की डिलीवरी होती है। वहीं प्लेज में ओनरशिप का भी ट्रांसफर हो जाता है डिफॉल्ट के केस में। फिर आता है दोनों में डिफरेंस क्या है। तो बेलमेंट जो है वो किस के लिए जो गुड्स की डिलीवरी हो सकती है, वहीं प्लेज के अंदर जो डिलीवरी ऑफ गुड्स होती है वो या तो किसी डेप्ट के सिक्योरिटी के तौर और या तो फिर किसी प्रॉमिस के परफॉर्मेंस के तौर पर भी हो सकती है। वहीं प्लेज में कंसिडरेशन जो है वो जरूरी होता है, मैंडेटरी होता है और बेलमेंट में जो कंसिडरेशन है वो मैंडेटरी नहीं होता है।
Next participant is Pranjal Sharma.
Good evening, everyone. Am I audible?
Yes, you are audible.
Thank you, ma'am. So I would like to start my topic. The topic which I have chosen for this one is privity of contract. So what do we mean by privity? The word privity is not an Indian concept. It has been adopted from the English law, coming from the interest theory. The major essentials are the parties should be directly involved. The parties to the contract, like the promisor and the promisee, are not for the benefit of any third parties. Third parties cannot sue for their very own benefit. Privity of contract is one of the most fundamental tenets in the contract law. It is of the most important concept which is practiced nowadays. Essentials for the privity of contract are: the contract must be entered between two parties, the promisor and the promisee, and any third party or a stranger cannot sue for their own benefits. Only the parties which are entered or a part of the contract can sue for the breach or non-performance of that very contract. A famous case is Dunlop Pneumatic Tire Co. versus Selfridge Limited, in which a third party, even if for his benefit, couldn't sue as he was not a party to the contract but was a stranger itself. There are some exceptions to this policy as beneficiary under a trust. If the contract is made for the benefit of a trust, then he or she can sue for it. The contracts made for family arrangements, the contract of agency, formerly known as vicarious liability, the acknowledgement or estoppel part, convenient running with the land, which is a very common practice for the contracts involving the sale and purchase of lands, contracts with statutory authority, which are also known as quasi contracts, which are formed by specific statutes, are to be followed by without following the principle of privity of contract. Thank you.
Next participant is Shaurya Singh. Next participant is Sauda Qureshi.
Good evening. Am I audible, ma'am?
Yes.
Good evening, everyone. My name is Sauda Qureshi. My topic is a definition of a valid contract and essentials of a valid contract. A valid contract is a legally binding agreement between two or more parties that is enforceable by law. For a contract to be valid, it must meet certain essentials which are stated under Section 10 of the Indian Contract Act 1872. According to Section 10 of the Indian Contract Act 1872, all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration with a lawful object and are not hereby expressly declared to be void. To explain the essentials, first is agreement. According to Section 2, subclause E, every promise and every set of promises forming the consideration for each other is an agreement. Free consent. It is stated under Section 14 of the Indian Contract Act 1872 that consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, mistake. Competent parties. According to Section 11 of the Indian Contract Act 1872, every person is a competent to contract who is of the age of majority according to law to which he is subject, who is of a sound mind and not disqualified from contracting by any law to which he is subject. Lawful consideration and object. According to Section 23 of the Indian Contract Act 1872, the consideration or object of an agreement is lawful unless it is forbidden by law, is of such nature that if permitted, it would defeat the provisions of any law, is fraudulent, involves or implies injury to the person or property of another. The court regards it as immoral or opposed to a public policy. In such cases, the consideration of object of an agreement is said to be unlawful. Every agreement which is unlawful is said to be void. Agreements expressly declared void. Agreements which are declared void by law and which are not enforceable by law cannot be a part of valid contract. Those are agreements made by incompetent persons with uncertain meaning, mutual mistake of fact, wagering agreements, unlawful object or consideration, restraint of marriage, agreements to do impossible act, restraint of trade, restraint of legal proceedings. Other essentials which are not given under Section 10 are two parties, no person can be buyer or seller both, intention to create legal obligation, capable of performance, certain meaning, there should be a certain meaning when you enter into a contract, and legal formalities. Thank you.
Next participant is Anand Kumar Bose.
Am I audible, ma'am?
Yes, Anand, you are audible.
Okay, ma'am. Greetings, everyone. My topic for the presentation is understanding Article 14 of the Constitution of India, the cornerstone of equality. So, I will give a brief introduction. Article 14 is a fundamental right under the Indian Constitution, which is present in the Part 4 of the Indian Constitution. It ensures equality before law and equal protection of the laws for all persons within India. There are some key concepts in this equality before law, which is a British concept. Everyone is equal in the eyes of the law. No one is above the law, be it a citizen, foreigner, or public official. Equal protection of law. It is an American concept. Similar individuals should be treated similarly in similar circumstances. Allows for reasonable clarification, not arbitrary discrimination. Reasonable classification. Classification is allowed if it is based on intelligible differentia. It has rational nexus with the object of the law. For example, special laws for children, women, or the economical weaker section. Important case laws would be State of West Bengal versus Anwar Ali Sarkar. Arbitrary laws were struck down. E.P. Royappa versus State of Tamil Nadu, which introduced the concept of arbitrariness being against equality. Another case would be Menaka Gandhi versus Union of India, 1978. It expanded equality to include fairness and non-arbitrariness in state action. I will also tell what Article 14 does not allow. No discrimination on basis of arbitrary grounds. State action must be just, fair, and reasonable. I will conclude my presentation with that Article 14 forms the bedrock of equality and rule of law in India. It protects both individual dignity and democratic fairness. It is the heart of Indian equality, and it basically is the basic structure of our Indian Constitution. Thank you.
Next participant is Angel.
Am I audible, ma'am?
Yes.
Good evening, everyone. I'm Angel, and today I'll be present about strict liability and absolute liability. So, starting with an introduction, tort law usually needs either negligence or intention for liability, but not always. There are some cases where a person can be held responsible even if they didn't mean to cause any harm or even tried to prevent it. This is also known as no fault liability, which established two major doctrines: strict liability and absolute liability. While they maybe sound similar, but absolute liability is stricter and doesn't allow for any defense, unlike strict liability. Strict liability basically means that if you bring something dangerous onto your property and it escapes and causes harm, you're liable, even if you took precaution. For example, if someone owns a Rottweiler and that has known a history of aggression, and after keeping it in a fenced area, it escapes and bites a neighbor, the owner can be held strictly liable. Now, the concept came from Reliance versus Fletcher in 1868. This gives up essentials, like there must be a dangerous thing, it must escape to cause harm, and third is the use of non-natural use of land. Now, the case of Reliance versus Fletcher, in this case, Fletcher built a reservoir, but water from it ended up flooding Reliance coal mines through forgotten shafts. And in this case, the court held that since Fletcher lands was used in a non natural way and the store water was dangerous once it escaped, he was strictly liable. Next, uh, in strict liability, there are exceptions also. Like if the plaintiff is at fault, like plaintiff's own default, if it was an act of God, like a natural disaster, if a third party caused it, or if plaintiff consented to the risk, or if the act was under the statutory authority. These exceptions provide some flexibility, and this is where strict and absolute liability start to differ, because in absolute liability there is no exceptions. The word itself says that this is the absolute liability, but in strict liability you may get some exceptions. Absolute liability. Now coming to absolute liability, it emerged from the Indian jurisprudence, especially after industrial tragedies like Bhopal gas leak. But the key case here is the MC Mehta versus Union of India. Now, here the idea is simple, that if a company is doing something inherently dangerous and harm is caused, they are liable. No excuses, no exceptions. Whether precautions were taken or not, it doesn't matter. Public safety comes first. Now, in the case, in 1985, oleum gas leak from a fertilizer plant in Delhi. This leak caused health issues, panic, and environmental damage. Now, the court held that industries dealing with dangerous substances have an absolute and non-deligible duty to ensure safety. So, when something goes wrong, they're fully liable even if they try to prevent it. That's what has done in the MC Mehta versus Union of India. Uh, to wrap it up, strict and absolute liability are crucial in tort law when dealing with hazardous activities. The main difference is that strict liability has exceptions and absolute liability doesn't. These doctrines shift focus from just blaming someone to actually protecting the society from dangerous enterprises. Thank you.
Next participant is Soumya. Soumya,
Yes, ma'am.
start your presentation.
Yes. My name is Soumya. I'm covering frustration of contract, which is covered under discharge of contract. Basically, firstly, I will explain what is discharge of contract, or when a contract is said to be discharged. When an agreement which is binding on the parties now ceases to bind them, is discharge of contract. Means earlier the parties are binded by it, now they are no more binded by it and they are discharged from it, that they will not perform. Uh, the basically it by ways we can discharge a contract are by performance of contract, by breach of contract, by impossibility of performance, that is frustration of contract. I will explain this. I will elaborate this. The fourth is by agreement and novation. First, doctrine of frustration. What the third point is doctrine of frustration of contract. Doctrine of frustration of contract uh, said that means it is basically covered under Section 56 of Indian Contract Act, and it means like if the performance become impossible because of supervening event, then the promisor is excused from performance of the contract. Means if some supervening event happened which led to or which is not possible, now contract is not possible to be performed. What is supervening event here? Like destruction of subject matter, unusual change of circumstances, death or incapacity. Destruction of subject matter means that the very basis on which the whole bargain was based is now not there. Like, let's suppose a person A and B are in contract. That A was like he will sell his horse and B will co- uh,
pay money for the same, and now horse is not alive, then it is not possible to sell the horse. No, this is destruction of subject matter. Now I will in Indian law we call it as impossibility of performance, but in English law we call it as frustration of contract. But Indian law is more wider than the English law because it covers both initial impossibility and subsequent impossibility. Now, I will explain what is Section 56 talks about the initial impossibility, the subsequent impossibility. Section 56 is such that agreement to do impossible, right? Okay, the first para talks about an agreement to do an act impossible in itself is void. Means from the initial stage, it is impossible to perform the contract. Like for I'm giving you an illustration. Like A agrees with B to discover a treasure by magic. The agreement is void. From the initial stage, it is not possible to discover a treasure by magic. So it is comes under para 1, initial impossibility. Then the para 2, that is subsequent impossibility. It covered that there are 2 points. Like it initially it is possible, but now it becomes impossible or illegal or unlawful to perform. Then it comes under subsequent impossibility, but there is one condition, right? That the promisor could not prevent. Means the if the promisor is capable to perform, or the subsequent event that is happening that led to non-performance of contract, then it does not come under para 2. Okay, the third part para talks about compensation. The third, there is again 3 points in para 2. That is, firstly, the promisor knew that it is impossible to perform, or by reasonable diligence, he might know that it is not possible to perform. Second point, the promisee does not know about the impossibility. And the third point, because of non-performance of the contract, a promisee has suffered some loss, then the promisor is liable for the compensation, and the promisee will be compensated for the same. Then there is a term which discussed with this is quantum merit. Quantum merit basically is when one party makes a breach of contract, like he does not perform his part or obligation under the contract, then the other party is entitled for the compensation. Then when he is entitled and how much he will be entitled for non-performance, then the party injured, that is the promisee, uh, mm, already perform some part from the contract, recover some remuneration whatever he already had done. Means he had performed some specific part of the contract, then he will be remunerated for the same. This is quantum merit. Then uh, th- uh, like there is a landmark case, that is Satyabrata Ghosh versus Mugniram Bangur and Company, 1954. In this case, the Justice Mukherjee explained about the Section 56 and on what basis this doctrine of frustration is basically dependent. Basically, there is must be impossibility of performance of contract. Second, he explained about that the party is absolved from further performance of the contract. Then then he talks about this that I have already discussed, the para one initial impossibility. The second, the para talks about the subsequent impossibility, and the third para talks about the compensation part. In second para, he also explained some points like subsequent impossibility, which led to change of circumstances which upset the very foundation of upon which the party rested their bargain. It means that because of change of circumstances or because of subsequent event, it laid that the very foundation on which the whole bargain is dependent, now it is not available to be performed, then it is void. Okay. This is all about frustration of contract. I hope you people understand it. Thank you.
Next participant is Shivangi Sharma.
थैंक यू सो मच मैम। मैम मेरी आवाज आ रही है?
हाँ आ रही है।
हेलो, थैंक यू सो मच मैम फॉर इनवाइटिंग मी। मेरा जो टॉपिक है वो है असॉल्ट। हम जानते हैं असॉल्ट जो है एक तरीके का क्रिमिनल ऑफेंस है जो कि बीएनएस के सेक्शन 130 में डिफाइंड है। अब असॉल्ट की अगर डिफिनेशन की बात करते हैं तो बैरेक्ट में जो डिफिनेशन दी हुई है उसमें उसमें अगर हम देखें उस डिफिनेशन को अगर तोड़ें तो उसमें कुछ कीवर्ड्स हमें देखने को मिलते हैं, जिसमें एक तो होता है कि कोई भी पर्सन अगर कोई जेस्चर ऐसा बनाता है या किसी भी तरीके का ऐसा प्रिपरेशन करता है, और ये जो जेस्चर फॉर्म हो रहा है किसी भी पर्सन के अगेंस्ट और जो प्रिपरेशन हो रहा है ये इंटेंशनली और विथ नॉलेज होना चाहिए कि जिससे जिस जेस्चर को बनाया जा रहा है किसी भी पर्सन के अगेंस्ट, उस पर्सन के अगेंस्ट किसी भी तरीके का क्रिमिनल फोर्स यूज हो सकता है। जैसे कि अगर कोई दो पर्सन है ए एंड बी, ए इस तरीके का जेस्चर फॉर्म करता है उस पर्सन को लेके बी को लेके कि वो अभी किसी भी तरीके का क्रिमिनल फोर्स उस बी पर्सन के अगेंस्ट अप्लाई कर देगा, तो इसी को असॉल्ट कहते हैं। दिस ऑफेंस इज नोन एज असॉल्ट। यहाँ पे एक ऑफेंस कमिट हो रहा है जिसे हम असॉल्ट कहेंगे। अब बात करते हैं कि किस तरीके का क्रिमिनल फोर्स। तो क्रिमिनल फोर्स ये भी बीएनएस में डिफाइंड है सेक्शन 129 में, जिसमें ये चीज मेंशन्ड है कि इंटेंशनली, अगर इंटेंशनली हम इस तरीके का फोर्स यूज करें किसी भी पर्सन के अगेंस्ट जिससे किसी पर्सन को फियर या फिर इंजरी कोई कॉज हो या किसी भी तरीके का डर यानी फियर या फिर किसी भी तरीके का अनॉयंस उस पर्सन के अगेंस्ट कॉज होता है या कमिट होता है, तब वो क्रिमिनल फोर्स की कैटेगरी में आ जाता है। अब असॉल्ट की एक एक्सप्लेनेशन दी हुई है जहाँ पे ये लिखा जाता है कि मेयर वर्ड्स, सिर्फ और सिर्फ वर्ड्स ही यूज करना किसी पर्सन के अगेंस्ट असॉल्ट की कैटेगरी में नहीं आता। हम सुनते हैं कि मुझे गाली दे दिया यानी मेरी असॉल्ट, यहाँ पे असॉल्ट नहीं हो रहा है। यहाँ पे असॉल्ट तब तक नहीं होगा जब तक हम ये सामने वाले पर्सन के अंदर उस रीजनेबल एप्रीहेंशन को न डाल दें, यानी आशंका ना जता दे कि हाँ हम उसके अगेंस्ट कोई ऐसा जेस्चर यूज कर रहे हैं जिससे उसे कोई इंजरी कॉज हो सकती है या कोई डर उसके मन में बैठा दे कि फियर ऑफ इंजरी हो सकती है या किसी भी तरीके का अनाउंस हो सकता है, तब तक ये असॉल्ट की कैटेगरी में नहीं आएगा। ये एक्सप्लेनेशन फर्स्ट जो सेक्शन 130 का है उसमें क्लियरली मेंशन है। और अगर असॉल्ट की पनिशमेंट की बात करें, जनरली जो पनिशमेंट है वो वेरियस कैटेगरीज में डिफाइंड है। जैसे अगर कोई पब्लिक सर्वेंट को उसकी ड्यूटी डिस्चार्ज नहीं करने दिया जाता है अगर इस तरीके की एक्टिविटीज करके, तब क्या पनिशमेंट होगा, तो उसमें हम देखते हैं कि 2 साल तक की पनिशमेंट जो है वो रेज होती है। साथ ही अगर असॉल्ट किया गया है किसी पर्सन के अगेंस्ट विदाउट ग्रेव एंड सडन प्रोवोकेशन, तब कम से कम यहाँ पे जो असॉल्ट की पनिशमेंट है वो 3 महीने तक बढ़ती है। साथ ही साथ 1,000 रुपए तक का फाइन भी लगता है। पहले ये फाइन कम था, बट आफ्टर जब बीएनएस हमारा 1 जुलाई 2024 से जब तक ये हमारे फोर्स में आया तब यहाँ पे पनिशमेंट को इंक्रीज कर दी गई। अब ये 1,000 रुपए तक की हो गई है। और यहाँ पे नॉर्मल केसेस में असॉल्ट की जो पनिशमेंट है वो 3 महीने तक मैक्सिमम जो है वो इंक्रीज होती है। और अगर हम बात करें, एक कॉन्सेप्ट होता है असॉल्ट एंड बैटरी का। असॉल्ट में आता है जिसमें जो बैटरी का कॉन्सेप्ट है, बैटरी का कॉन्सेप्ट हमारे इंडियन लॉ में अप्लाई नहीं होता, ये इंग्लिश लॉ में अप्लाई होता है। असॉल्ट का तो ठीक है, हमने कह दिया कि हाँ अगर कोई रीजनेबल एप्रीहेंशन ही हो रहा है ये कॉज करना का कि हाँ क्रिमिनल फोर्स किसी पर्सन के अगेंस्ट अप्लाई हो सकता है, तब तो यहाँ असॉल्ट हो गया। लेकिन बैटरी उसी चीज का एक्चुअल एप्लीकेशन होता है। हम यहाँ पे उसको रीजनेबल आशंका नहीं जता रहे, हम सच में कोई क्रिमिनल फोर्स पर्सन के अगेंस्ट अप्लाई कर रहे हैं। जैसे कि अगर मान लीजिए मैंने किसी को ये जताया कि नहीं मैं उसको थप्पड़ मार दूंगी और सच में मैंने मार दिया, तब तो यहाँ बैटरी कमिट हो गई, यहाँ असॉल्ट नहीं हुआ। लेकिन अगर मैं ये रीजनेबल एप्रीहेंशन दिखाती कि नहीं मैं थप्पड़ मार ही दूंगी लेकिन मारती नहीं, तो यहाँ पे असॉल्ट होता। अब यही दोनों डिफरेंस होता है। बैटरी से रिलेटेड अगर हम इंडियन लॉ में एक कॉन्सेप्ट देखें तो एक आता है यही क्रिमिनल फोर्स का जो सेक्शन 129 में डिफाइन है। ओके, थैंक यू सो मच मैम, दिस इज ऑल अबाउट।
Okay, so I'm taking their names again who came late. First one is Tanveer Digra.
Yes, ma'am.
So you want to give your presentation now?
Yes, yes.
So start.
Okay. One second. Good evening to all. My topic of presentation is bailment. So, under Section 148 of Indian Contract Act, the bailment is a delivery of movable goods from one person to another person for a specific purpose. And once this specific purpose is completed, the person to whom the good is delivered has to return back the goods. So, who delivers the good is called bailer, and who gets the delivery of a good is called bailee. For example, a car owner has delivered the possession of his car for the repayment to the garage owner. So in this case, the car owner would be called bailer and the garage owner would be called bailee. And the bailiff's right is that he has a right to terminate the bailment if bailey's act is inconsistent with the conditions set up by the bailer. And bailer is also entitled to incur profit from the goods he has bailed. For example, he has given a cow for a rent to a bailee, and in that process, if a calf has been born in under that process, the bailee has to return back the cow as well as calf. So bailer's liability is that bailer duty is to disclose all fault in the goods bailed. So here is the bailer's right. If it comes to the bailey's right, the bailee, in absence of any special contract, is not responsible for the loss, destruction, or deterioration of things bailed if he has taken a good amount of care of it. And the second right of a bailee is that he has a right to particular lien, like if he is selling some specific skill, labor, or service. If it is used in the bailment process, then he is entitled to retain till he paid the services he has rendered. Thank you so much.
Next one is Rakhi Jha. Next Shagun Joshi.
Am I audible?
Yes.
Good evening to everyone. Myself Shagun Joshi. Today I am going to present leading case of Carlyle versus Carbolic Smoke Ball. So firstly I am going to explain offer and acceptance. Under Section 2A of Indian Contract Act, when one person signifies to another his willingness to do or to abstain from anything with a view to obtaining the assent of that offer to such act and of substance, he is said to make proposal. And the essentials of the offer is intention to create legal relation, clarity of the definiteness, communication to the offer, distinction from the invitation to trade, and no non-acceptance clause. And the acceptance is defined under Section 2B of the Indian Contract Act when the one person is to whom the proposal is made to signify his assent thereto. The proposal is to said to be accepted. A proposal, when accepted, becomes a promise. The Carlin versus Carbolic Smooth Bog Company case established a validity unlimited contract and clarified the principle of offer acceptance in Indian contract law. The main fact of the cases are the Carbolic Smooth Bog Company advertised their product claiming it would be a prevent influenza and other disease. They offered £100 reward to anyone who contracted influenza after using their smooth balls and as directed. They further stated they had deposited £1,000 in bank to show their sincerity in the offer. Mr. Mrs. Carolyn purchased and used the smoke ball as directed but still caught the flue. She sued the company to claim the £100 reward, and company argued the advertisement was not binding on the contract. The judgment was given in this case was the court held that the advertisement was a valid for the unilateral contract using the smoke wall as a directive constituted accepted of the offer. The deposit of £1,000 demonstrates that the company intention to legally bound the inconvenience of using the smoke balls and the potential for the increased sales constitute sufficient consideration for the promise. Therefore, the court ruled in favor of a Mrs. Carlyle and requiring the company to pay £100 in the reward. Thank you.
Next participant is Purna Sahu. Abhinav Sharma, Tanya Barnawal, Shaurya Singh, Utkarsh Yadav, okay, with due respect, I hand over this mic to Hemant sir. Please, if you have any questions, then you can ask to all the participants. I hand over my mic to you, sir.
Hello, good evening to all the participants who are present here. Am I audible?
Yes, sir.
You all have presented your topics very well, but there are certain things which I would like to tell you. Firstly, you should keep this in mind that while you are presenting your slide in front of anyone, then you should keep your introduction, your content, and your conclusion in a best way in the front of the panel or any person to whom you are presenting your topic. As if your introduction will be attractive, then your presentation will be good. And it was also appearing like some of the people were just reading from their PPT and the cameras were off. If you will do this in the future, this will make your presentation unattractive. So always keep this in mind that you have to maintain a good eye contact with any person in front of whom you are presenting your uh, topic or the arguments. Okay. So with this, I would like to convey my best wishes to all the participants, and I would like to congratulate the committee for organizing such a wonderful session. So with this, all the best. Thank you.
Okay, thank you so much, everyone, for joining this meeting. Now you can leave this meeting. Thank you so much, everyone.
Okay, ma'am. Thank you, ma'am.